Good afternoon, everybody. Welcome to the Citizens Advice Information for European Nationals webinar. Citizens Advice Richmond offers a range of activities funded by Richmond Council to help EU citizens deal with Brexit, including presentation, talks in the community, and we also provide one-to-one advice to anybody who lives, works, studies, or cares for somebody in the Borough of Richmond. All of our presentation slides and our video of this webinar will be available on our website, hopefully by the end of the week, and we'll notify everybody once that goes live. So I will now hand over to our EU advisor, Mike Horan, who will take us through the slides.
I'm going to take you through a slideshow which sets out the main rules. I might add some further detail on the points that might cause any difficulty. So let's head off. So the present position is there is no change at the moment for EU citizens and their families in the UK. Nothing has changed in the law. EU citizens continue to have a right to enter the UK until the end of December this year, 2020. So free movement continues during what's called the transitional period. And in the last few days, you've probably read that the EU and the UK have agreed that there will be no extension to the transition period. So free movement will end on the 31st of December this year, 2020. But the most important thing to take out of this meeting is, if you haven't done so already, if you want to remain in the UK long term, you will have to apply for settled status or pre-settled status if you haven't been here for 5 years. And the deadline for that is the end of June, 30th of June, 2021. So not this June, not the end of this month, it's a year's time. Okay, so let's look at some further detail. Settled status. Well, all EU citizens and their families who are living in the UK can now apply for settled status. A point to emphasise is that if you have a permanent right of residence card, and you'll know that because it will say permanent on it, or you're married to a British citizen, you still have to apply for settled status. There's a lot of confusion about that, so please note that, particularly if you have the permanent right of residence card. It doesn't exempt you from applying for settled status. There's two groups of people who do not need to apply, and they are Irish citizens, citizens of the Irish Republic, or if you have something called indefinite leave to remain. Now, indefinite leave to remain was only given to EU citizens up to 2006. So if you arrived after 2006, you won't have this. The other point is you must have applied for it. So if you didn't apply to the Home Office for some document, again, you haven't got indefinite leave to remain. What's sometimes confusing is people who applied for this a very long time ago would have had a stamp in their passport, and that passport could be an old passport. More recently, you would have received a card, so it's sometimes difficult to tell whether you've got indefinite leave to remain. We can, of course, advise you on that. Now, people with indefinite leave to remain don't need to apply for settled status, but as we'll come to later on, it might be a good idea, even if you're exempt, to apply. Settled status, so what do you need to get settled status? Well, the rule is you have to have lived in the United Kingdom, to be resident of the United Kingdom, continuously for 5 years. You only lose that if you're out of the UK for 5 years. So if you lived here for 5 years and you left for 5 years, you have to start again. Now, there are some exceptions. You don't need to be in the UK every day for 5 years. You can be absent, actually, for as much as 6 months in each year. So each of the 5 years you're relying on, you can be out of the UK for half of the time. You can also be out of the UK for 12 months for important reasons. An example given is family illness, and again, if you want advice on that, we can advise you if you can take advantage of this exception. If you're not in the UK for 5 years at the moment, you'll get something called pre-settled status. This is a sort of temporary permission to remain, and at the end of the 5 years you can then apply to convert that to full settled status. Another point to remember is if you are, because we said family members can apply, you could be a family member of an EU citizen, but not an EU citizen yourself. For example, you could be the Japanese spouse of an Italian citizen, Japanese husband or wife of an Italian citizen. The Japanese citizen is not an EU citizen themselves, but they are a family member. Family members can apply. Now, family members don't automatically get settled status because their EU citizen family member has themselves got settled status. They have to run up the 5 years themselves. So that's worth remembering. The exception is children, which I'll talk about in 1 second. So just a bit more detail. There's 2 exceptions to the 5-year period. I have to say, in Citizens Advice Richmond, we have never come across these, but I'll mention very quickly. If you have worked in the United Kingdom and then retire, so you came to the United Kingdom close to 65, 66, and you retire, or you become permanently incapacitated, that means permanently unable to work, then get advice. You will be able to apply in either 2 or 3 years. And similarly, if you're a family member but not an EU citizen, and the EU citizen has worked or died in the UK, again, you can apply with less than 5 years. Those cases are rare. If you know anybody in those categories, please ask them to see us. Now, I'd like to go into the application. A lot of you will have applied already, so I'll go through this quite quickly, but also it's worth you knowing, because you may have friends or family outside Richmond who are not here today who want to know about the process. So you need an identity document, and that will usually be a valid means up to date, so current, a passport, or a valid up-to-date national identity card. We in the UK don't have identity cards, but many EU countries do. The simplest form of identity will actually be an up-to-date, valid biometric passport. All modern passports are biometric. You can tell if they're biometric because there is a small box on the front of the passport. If you're not an EU citizen, there are other documents you can rely on. They are in the slides. I'm not going to talk about this. Now, occasionally, very rarely, you might have somebody who doesn't have a current passport, doesn't have a current national identity card. It is possible to apply under the scheme with some other proof of identity. I have a client who has a very old national identity card. In this case, you have to send the document in to the Home Office. So the application, as many of you will know, has 2 parts. There is a scanning part, and this involves you're scanning your passport, and you scan your face to read your distance between your eyes, things like that, and also take a selfie, take a photo of yourself. And you can do this using an app. The details of the app are on the screen. You must have an Android phone you can use for contactless payments, or an iPhone version 7 or later. And we've given you the details of where you can get the app from. I'd like to say a word here about the app because it sometimes causes confusion. A lot of people are thrown by this. If you have teenage children, I'm sure they can download the app for you and do the scanning. Some people find even if they've downloaded the app, they do have a problem with the scanning. It doesn't always work after a few tries. Now, Richmond Council, most councils actually provide a service. They will do the scanning for you. So everything is down to them. They have the equipment. You don't need a special phone. You just make an appointment to see them. At the moment, and I checked half an hour before the meeting started, Richmond Council scanning service is still closed. We don't have a reopening time. What I suggest you do is, after the meeting, keep this link, which is showing on screen, and check maybe weekly to see when the service reopens. Please don't worry about delay. You have, as I said, more than a year to apply. So you can do the scanning yourself. If there's any problems with this, Richmond Council has a scanning service. Citizens Advice Richmond can also do this for you. We give priority to people over retirement age. So returning now to the material, the second part of the application is an online form, and compared with most government applications, this is very straightforward. I will take you through the questions in one moment. You do not have to be worried about being timed out. You don't have to do the whole application in one go. You can save your answers and come back again. So you complete the form, and usually you will not have to send any documents away unless you don't have a valid, up-to-date identity document, i.e. a passport or an identity document. Now, I'm going to take you through very quickly, just to show how easy the application is, the question. There's only about 6 questions, so let's go through these fairly briskly. The first question is, do you have dual nationality? Did you have more than one nationality? They also ask, did you have a previous nationality which you have now lost? They then ask, do you remember we said before, permanent right of residence card? Do you have that? You're not exempt from applying. And they ask, do you have indefinite leave to remain? The reason they ask these questions is because they then won't ask for any proof that you lived in the UK for 5 years. You're automatically treated as living in the UK for 5 years, and you will actually have lived in the UK 5 years. If you're not certain, again, we can advise you. If you're not certain, you can tick the box no. It doesn't matter. You're not doing anything wrong. The application will want to know your address. It asks if you have any other names. What it means by that is, do you use any other names than those shown in your passport or your identity document? It asks for your national insurance number. Some people won't have one because they won't have worked or claimed UK benefits. That's fine. And finally, there is a question about convictions, criminal convictions. This means anywhere in the world. It does include motoring offences where there is what's called a court summons. So it's a letter from the court, but not a fixed penalty, not a local council fixed penalty. Please don't worry, you have no problems getting settled status for minor offences. That's not a problem. If you have a more serious conviction, please get advice. You can come to us. So what happens then? Now, once you press the button, submit your application, the government will automatically check their own records, and they will check 2 sets of records. They will check the records of what's called HMRC, our Tax and National Insurance Department, or the DWP, which is our Benefits Department. Usually, for probably more than half the people who apply, that will be enough. The government records will show that you have been in the UK for 5 years and you qualify for settled status, or that you've been in the UK for some period and you qualify for pre-settled status if you have lived here less than 5 years. Now, for some people, you will receive an email saying we need further evidence of your residence in the UK. Please do not worry about this. This is due to problems technical problems with the government records. They may have no records for you. the records may be quite old and they're not computerized. Please do not worry. We have helped dozens of people with their applications, and in every case, we have been able to find documents to prove residence. Very, very little is required. I'm sure there will be questions about this, but please do not worry. And then finally, the government checks on your criminal convictions before making a decision. You're usually told very quickly if you will be considered for settled or pre-settled status, or if you need to provide more evidence. That part is automated, so that is not affected by the COVID crisis. The Home Office, the government department dealing with settled status, will email you with the outcome. Now, there are delays at the moment because civil servants, people have to look at the application once it's submitted online, and government are warning that there are delays for people who applied before March the 23rd. So with your decision letter, and in every case we have assisted, people have either got pre-settled status or full settled status. You will get an email that will give you a link to an online database, which is the official record of your settled status. You do not receive a residence card if you're an EU citizen. You do not receive a residence card. That is the government decision. People get very worried about this. Please do not. The email has a letter attachment. You can print that letter out. It's not technically proof of settled status. The database is the proof. But we have found that all government departments are accepting this letter. The benefits departments, housing departments, tax authorities are accepting this letter, which says you have been granted settled status, of proof of your settled status. There is lots of help online. There is help from us, but there is also help from government. They can help you with the online application. There are phone numbers, which, unlike most government departments, are very easy to get through to. They're very, very helpful. And there's also help online. I'm not going to talk about that, but the information is there for you. I'm not going to say too much about family members. Family members are important where the family member is not an EU citizen. From our experience of previous live talks, few of our audience are non-EU citizens. So I'm going to go through this quite quickly. So a family member of an EU citizen has a right also to apply for settled status, but remember they must also have the 5 years in the UK. And a family member is a spouse or a civil partner, what's called a durable partner. That means you live together for 2 years. A child or grandchild who is under 21 or dependent, being kept by the EU family member, or you could actually be a dependent parent or grandparent. There are special rules for the family members if the EU citizen dies or leaves the UK or divorces. In other words, the family relationship ends. I would suggest you get advice on that. If you're an EU family member, you can do your application at the same time as we would recommend that as the EU member of the household. And you can tick a box saying you want them linked, so they will look at the applications together and there is less information they need. Just a word about what happens after Brexit. So if you have settled status and you have family members outside the UK, they can actually enter freely until March 2022. And if you have a new family member, a new relationship, then entry ends at December 2020. So if you've got existing family, there is a special rule allowing those family members to enter until March 2022, 29th of March. A child who is born or adopted can enter even after, so a child of an EU citizen who has settled status, who's born or adopted even after the end of the transition period, December 2020, can freely enter the UK. So let's just, you have your settled status. What effect does this have? It means residence, but let's look at a bit more detail. Settled status is only lost by 5 years absence from the UK. Now that's much better than the indefinite leave to remain or the permanent right of residence, because they were lost by 2 years absence from the UK. And that's the reason, even if you have indefinite leave to remain, we would advise you to apply for settled status. 2 reasons. One, the old indefinite leave to remain might be a stamp in a passport. The passport could be quite old. You have to carry that with you. That's inconvenient. The second reason is that you will lose your indefinite leave to remain if you're outside the UK for more than 2 years. But if you have settled status, you can be outside the UK for up to 5 years without losing that right. And then the other important thing about settled status is if you're not married to a British citizen, you can apply for what's called naturalisation. That's, you can apply to be a British citizen after 1 year after you receive settled status. If you're married to a British citizen, you don't have to wait. That does not mean that is automatic. You have to satisfy the other rules for naturalisation, for becoming a British citizen. You can actually apply for British citizenship also after you have indefinite leave to remain or the permanent right of residence document. So you have to have something to say your long-term right to be in the UK, and that can be 3 documents: settled status, indefinite leave to remain, permanent right of residence. Naturalisation, the process of becoming British, can be complicated, and again we would advise that you get advice before applying. So in summary, your rights are unchanged until the 31st of December 2020. You must apply for settled status or pre-settled status by the end of June, 30th of June 2021. The 2 exceptions are you're an Irish citizen or you have indefinite leave to remain. On the Irish citizen, that does not exempt the family member. So to take my example of a Japanese citizen, an Irish citizen, citizen of the Republic of Ireland, is in the UK, does not need to apply for settled status, has a spouse who is a Japanese citizen. The Japanese citizen will need to apply for settled status and will need to have lived here 5 years before getting the full settled status. They can apply temporarily for the pre-settled status, but they must do that, do that before June 2021. And the test for almost everybody to apply for settled status is you have to be resident, you have to be living in the UK for 5 years. Children do not, who are under 21, can apply at the same time as their parents and do not have to have lived in the UK for 5 years. So very young children can apply, but children do have to apply. Again, sometimes misinformation about children, but children of EU citizens, unless they're Irish or unless they have indefinite leave to remain, they do need to apply for settled status. Now there is lots of information available. I'll just go through this quickly. We have the links to the material. All this will be on our website shortly. You can sign up for email updates from the government I don't think you'll find them very useful now because the scheme has now been running since last April. There will be no changes in the settled status scheme before the cut-off date, but you might be interested in receiving material. There are useful statistics. Something like 90% of EU citizens who are eligible have now applied for settled status. There is very useful information on the government website, that's Gov.uk, on becoming a British citizen, sometimes called naturalisation. That's how an adult becomes a British citizen. There's also information, we think better information, from the Children's Legal Centre. This is a special law centre for children, on registering a child to be British. This is the process by which a child under 18 can become British, which is more straightforward than waiting to be 18 and then applying for as an adult. Again, there is lots of information from Citizens Advice Richmond. There is the link there showing the best way to contact us is email. You can, of course, phone. We're open Monday to Friday, 10 to 4, and that's our number. If you email us, you have, of course, the opportunity to set out your problem in detail. It would be helpful if you could put in the subject box something like EU inquiry, and those inquiries will then come to me because I specialise in this area of advice. You can also sign up for email updates from us. This is separate from the Home Office, and again, the link is there. So any information we have about the scheme. So we sent out email updates when the Richmond scanning centres closed. There were certain changes during the COVID crisis. They no longer apply, so I won't talk about those. So it's a way of keeping up to date. I'm actually going to finish there my presentation because we're expecting quite a lot of questions. So I'm going to hand over to my colleague and my boss, Bradley, to introduce the question and answer session of this webinar.
The contact details for us. So if you do want some further information on this or any information from Citizens Advice Richmond, the easiest way to contact us is through our email us contact page. There is an online form for you to complete. And it will just give us time to do a bit of research and make sure that the best possible person gets back to you. Alternatively, if you do want to speak to somebody, first of all, we do have our contact number, which is open Monday to Friday, 10 AM to 4 PM, and that's on 0300 330 2114. And that is answered by our generalist advisors. They will run through an assessment with you, and if they do need to pass you on for further advice, they will do so, and a callback will be arranged to discuss some more information with you. First question was, is settled status valid in law opposed to policy in case of a no-deal Brexit?
The question of no deal is really out of the way now. We've now moved it beyond that. But to answer the question, is settled status a policy or is it law? It most definitely is law. It is in British legislation. It's there. We're looking at it every day. So it is not just a question of the government exercising some discretion, being nice to you, saying you can temporarily stay here. It is in the law, and if there ever was to be a change in that, it would have to go through Parliament in the ordinary way. So it is law in the same way as any other law in this country.
Our second question. So for the 5-year rule to apply on the date of entry in the UK or the day that you applied for pre-settlement, for example, entering the UK at the beginning of June 2016, but not applying until July 2019, when does that 5 years start from?
Right. All you need to do is, and don't forget, you can be out of the UK for, half the time. You'd be out of the UK for 6 months a year. You have to have a period of 5 years in the UK. I was just looking at the question: if somebody enters the UK in June 2016, they wouldn't be eligible for full settled status until June 2021. Okay. People sometimes get worried about what happens if the 5 years is after the date you have to apply by next June. Don't worry about that. What you do in that case, if you don't have 5 years living in the UK, you apply for pre-settled status, temporary permission to be here. You must do that before the end of June 2021. And then when you have 5 years, you then apply for the full settled status. So if you're here for a short time, you apply for what's called pre-settled status. If you've been here longer, but you've had, for example, periods when you've been outside the UK for more than 6 months, so that those years don't count. It doesn't matter when the 5 years were. The 5 years could be a long time ago. The only thing that would make you have to start again is if you're out of the UK for 5 years. So one more example, you're here from 2009 to 2014, and then for the next 2 years you're back in your own country, and then you return to the UK. Later, you wouldn't have been here this time for 5 years, but in the past, you did have a period of residence in the UK. So any period of 5 years will do. The only way that doesn't apply is if you left the UK for 5 years.
Our next question is in regards to the parking fines, so parking tickets. Even though it doesn't mean an offence for settled status, do you have to still declare them, or are they considered as a minor in any application?
Right. The motoring offences are probably the most confusing thing there is, because in the UK, they are sometimes technically criminal offences. Please don't worry about me saying that, but they're often not. It's quite difficult without seeing the document you received, but very roughly, if you receive something from a magistrate's court, it's called a summons, then you will have to declare that. You don't always have to go to court for motoring offences. You don't physically have to go to court. You can often complete some papers, and that causes confusion. If, on the other hand, you receive something called with the words fixed penalty, that is not actually a criminal matter. Please don't overly worry about this. Again, we've dealt with lots of applications with people who have very, very minor, usually motoring offences, and they have had no problem receiving settled status. But be very careful. There is no exception. So anything that started in a magistrate's court, that's a good test, will strictly be criminal, even though it's quite minor. You should tick the box saying, I have a criminal conviction, because the Home Office can refuse the application if the information is misleading, even though the conviction is very, very minor. It won't affect you.
Our next question is, if I choose to apply for settled status after the 31st of December, how will I enter the UK until a decision is made? So what will be my rights to enter or leave?
Yes. Okay. So this is where you don't apply for settled status until after December. The reason is, it may sound very odd, but although free movement finishes at the end of December, the government are actually going to carry out nonEU checks on EU citizens. That may sound odd, but the main advantage of free movement, is working. So there are separate checks on working. So people who come to the UK for the first time after December 2020, it will be easy for employers to find out whether they have a right to work. So please don't worry about leaving on holiday, for example. You leave, you haven't applied for settled status, or you might have applied for settled status, but due to the Christmas holiday, there is a delay. You put the application in early December, you're waiting please don't worry. Travel freely. It's not a problem. Don't forget that you will scan your passport. You won't be sending your passport anyway. You will have your passport or your identity card. You can take that, travel, and you will not have any problem returning to the UK. But again, please remember the deadline is 31st of June 2021. You must apply before then.
Is a home rental contract sufficient, or is council tax bill sufficient proof of being resident in the UK?
Yes, we often get a lot of questions about proof of residence. So just to repeat, I'm sorry if I'm saying the same things again, but sometimes it is worth doing this. When you fill in the application, the government will check your tax and your benefit records, and for more than half the people who apply, that is enough. They will find out from their own records that you have lived in the UK for at least 5 years, and you will receive the settled status. You will not be asked for further evidence. Now, for some people, in my experience, it's usually people who have retired. For some reason, even though they are receiving a UK state, it's a government pension, and you would think the government records would show they're living in the UK. I don't know why this is a difficulty, but sometimes those people are asked for further proof of evidence. So to answer the questioner, certainly those documents would be enough. Let me take an extreme example. This is very rare. The government emails you and says, thank you for your application. We can find no evidence that you have lived in the UK for 5 years. That's rare. It's usually we have no information for this period. So people, again, get very worried about this. Please do not do so. The government recommend that you provide something to show you are here for 2 periods in each of the 5 years. The reason for that is you can, of course, be outside the UK for 6 months in a year, and they just want some evidence, 2 pieces of evidence for each year. So a tenancy agreement by itself may not be enough. The reason for this is the tenancy agreement will show the date you agreed with your landlord to move into the property. It doesn't necessarily prove you were there all throughout the period of the tenancy. Council tax bills are different. You will only receive a council tax bill if you are living in the UK and living at that address. Certainly a number of council tax bills spread over the 5 years, that will certainly be enough. I'll just give some other quick examples. Gas, electricity, water bills, utility bills, phone, internet service bills, absolutely fine. Some people provide bank statements. We have seen those people and we've just removed anything sensitive. We've just erased any entries that are sensitive. Some people have provided medical records. I don't advise that, but again, one client had lots and lots of GP and hospital appointments, so we submitted that information, just removed all the details of her medical records, but the information showed the dates she had the appointment. So it's, please don't overly worry about this. It's a minority, but a lot of people are asked for further information. We have never found one client who cannot find enough, and we can advise you what enough is. You do not need proof that you are here every day or every week or even every month. They just want a few pieces of paper, for a couple for each year, for each year they are asking for. So the worst that will happen is they will say, we want information for 5 years, and you will be able to get that information. You will not have a problem.
So there has been quite a few questions around pre-settled status. Yes. So generally, what are we entitled to? How long can you stay out of the UK before losing settled status? And there has been one new question, which with regards to pre-settled status and I suppose settled status, will those be set in stone, or are the government allowed to change their mind at some point in the future?
Okay, let me deal with the last one first. We often get questions about what might change. You know, the silly answer is anything can change, but you know, we are here to give you proper advice. So both settled status and pre-settled status are in the same law. So the previous question was about settled status, but pre-settled status is also in the law. I see no reason to think that either of those will change, not certainly before June, and by June everyone who has to apply will apply. I personally think there might be an extension of the time for applying, but please don't rely on that. So, you know, there is no reason to think that these will change. Now, I then like to take the one about what's the difference really? What is pre-settled status? Now, pre-settled status is temporary. I'll talk about the length of the pre-settled status in 1 second. It doesn't give you quite the same rights in the UK as settled status. So obviously you still have the right to work here in the normal way. Pre-settled status doesn't by itself give you a right to claim most UK benefits, and doesn't by itself give you a right to apply for UK public housing. Don't worry too much about this, because you might have a right to those anyway. This is a complicated area, but for example, if you're working, if you're self-employed, if you're on maternity leave, if you're looking for work, you're sort of signed on with the job centre, if you're registered with the job centre, you're looking for work, all of those give you rights to claim UK benefits and UK public housing. You can always rent privately. The exception is if you're not in those categories. Settled status is fine. Settled status is resident. All residents in the UK have the same rights to benefits and housing as UK citizens. So if you're not economically active or looking for work, pre-settled status doesn't give you as many entitlements. There are court cases about this, but at the moment that is the position. It is a complicated area. If you find that you have to claim a UK benefit or seek public housing, and you have pre-settled status, so you have less than 5 years, please get advice from us. Now, the final question, this is slightly complicated. The question of the pre-settled status, how long does it last? And fortunately, I did some research on this question because I thought it would be asked. So pre-settled status can last for up to 5 years. The reason, of course, is because you might arrive in the UK now, you can do. Free movement continues until December. You immediately apply for pre-settled status. You cannot apply for settled status until you have lived in the UK for 5 years. So that's the maximum. Now, in theory, pre-settled status is lost if you're outside the UK for 2 years. You might read about this. Be very careful. So you have pre-settled status and you leave the UK for quite a long time. You leave the UK for, should we say, a year, more than a year. Now, you still have the pre-settled status. You can return to the UK, but you've left the UK more than a year. Now, just go back, you have to live in the UK 5 years most of the time. So but you can be absent for up to half the year, but you've got to live in the UK most of the time. If you're away from the UK with pre-settled status now for, so we say, a year, you then would have to start again. And the reason you have to be careful is you can only make a new application before June 2021. So this is a complicated area, but I would say if you have pre-settled status and you are thinking about leaving the UK for more than 6 months, please get advice. You may come within the exception. Do you remember at the beginning we said that you're allowed to be out of the UK for 6 months in any of the 5 years, but in exceptional circumstances, if a family member is ill, for example, you could be outside the UK for a year. But there are other examples in the guidance. But if there are not exceptional circumstances and you want to remain in the UK long term, you do not want to be outside the UK for more than 6 months. So if you're proposing to do that, please get advice. We can of course advise you about that, but we need to know the individual circumstances. And a webinar like this, we can't really go into too much detail about individual circumstances.
So if an EU national gets settled status and they then want to marry a non-EU national, will the same rights still apply? So can the EU national bring that person to the UK under EU law if they're doing it before December 2020?
Yes, I have to think about that, but yes. So the non-EU family member can enter the UK as the family member of an EU citizen up to December of 2020. If they don't enter the UK until after that, of course, there will be a way to live together, but the more complicated, more and more onerous, more difficult UK rules will then apply. So if there is some reason why the non-EU partner cannot enter the UK by December, again, I'm going to say, I've said this many times, please get advice, and of course we can advise you on that. But it would be better if the non-EU national enters before the end of the year, not after.
So the next question is regarding those with settled status. So I've been granted settled status. Does this mean that my family can come freely to stay with me for short visits until March 2022 without asking for any permission?
Right, okay. Well, you said short visits. There is no reason at all to believe that that Brexit, the UK leaving the European Union, will change any of the rules on short-term visits. This is entry as a visitor. At the moment, for example, if you're coming from a non-EU country and you don't need a special visa, most countries, for example, America, Japan, a citizen from those countries can freely enter the UK for a visit for up to 6 months. So there's absolutely no reason at all to think that Brexit will have any effect. In some ways, this is really nothing to do with Brexit. This is just the question of what happens to visitors. So there should be no problem whatever in those family members coming for short visits. It doesn't matter when.
So this one is, I've seen in the media that some applicants were refused citizenship because they did not have comprehensive health insurance, having previously been granted settled status. So is it, I'm assuming that's for a permanent right to reside, is it required for settled status now?
Okay, now I'll try to keep this simple. So it is the case, the question is asking about the need for private medical insurance. Now, in the past, if you applied for the permanent right of residence document, which if you don't have this, please forget about it, because this is old now. You sometimes, but only sometimes, had to provide proof that you had comprehensive medical insurance, in other words, private insurance that covered all treatment. And the reason for that is that some EU citizens could get the permanent right of residence by working or being self-employed or looking for work. Others were living on their own savings or maybe income from their home country. And those people, what are called self-sufficient people, under, this is EU law, had to have a private medical insurance to get the permanent right of residence. So this is old history, if you like. So we don't need to worry about that. Now, the question then is, do you need any kind of medical insurance to apply for settled status? That's very easily answered. The answer is no. The only test for, well, there are two tests really, for settled status is, do you have 5 years resident living in the UK with a lot of time allowed outside the UK? And secondly, we haven't talked about this, but if you have very serious criminal convictions, your application is likely to be refused. We have never had a case like that. So subject to those two rules, there is nothing else. All the requirements for the old permanent residence document have been dropped. You do not need to have worked, you do not need to have been self-employed for the 5 years, to be living on your savings, and you certainly do not need to have had the private medical cover. So that requirement, it does not apply to settled status. Please do not worry about this.
So the next question is regarding transferring from pre-settlement to settled status. Is it an automatic process, or do clients have to do something specific? So if I could ask you that. And then there's been a couple of queries around how long applications for this, so changing from pre-settled to settled, but also some questions around the length of time it takes for a settled status application to be processed.
Okay, on the first one, I'm afraid you do have to apply. It's not automatic. So you have pre-settled status, you then have to apply to convert this. I mean, it's much easier. You don't have to go through all the scanning business again. You go into your application. If you've forgotten your password, you can send an email and you'll get those back. You don't have to provide a lot of further information. You just have to declare that you have lived in the UK for the extra period, so to make up the 5 years. So you do have to apply. It's much simpler. You have to do the application, but you don't have to do the scanning, and there are less questions asked. Now, on the other 2 points, there's really not much I can say. The reason, of course, is the reason we're doing this webinar, because of the coronavirus crisis. Up to March, applications were taking a few weeks. If there were complications, further documents were required. I think the longest I had was 2 months for both pre-settled status and settled status. Now, we were warned very soon after March the 23rd that all government offices dealing with settled status applications were closing, so you could still do the application online, but nobody would look at the application. No civil servants would look at this. Now, the offices are now open, the phone advice service is open, the email advice service, they're all open, but there is a backlog. Citizens Advice nationally were advised that decisions are taking longer. I'm afraid I don't have any current estimates on how long applications are taking. I would still advise, if you have not completed the application, you do so as soon as you can. If you need help with the scanning, either we or Richmond Council should be open. We hope not too long. Please don't delay. There will be a backlog. It may take some months. As soon as we have an estimate of the likely delay, we will send this out if you sign up for our email updates.
Okay, so this is a question regarding pensions. So what would happen to our pensions if we've got settled status but decide to live abroad before we access the pension pot in the UK?
Okay. Yes, we often get questions about pensions, and that's quite understandable. Absolutely no problems at all. So first of all, private pensions are they are contracts, if you like, between you and the pension company, and it doesn't matter where you're living. You can, of course, receive your you can receive your pension wherever you are living. The question of the state pension, that's the government pension, again, that is not a difficulty. Special arrangements have already been made between the UK and the remaining EU states. Two special arrangements. You can always take your state pension abroad. To the EU. You can take your pension anywhere around the world, British pension. But secondly, the way the pension is calculated will take into account any periods of residence or insurance you have. So, for example, the UK pension is calculated on the basis of national insurance, social security contributions that you make over your working life. And that takes into account your contributions if, for example, you worked in another EU state, maybe your home state, before you came here. So the only thing to be careful with, and this is nothing to do with Brexit, is if you take your state pension, your UK state pension abroad, so you're drawing the pension, but you're living outside the EU. Outside the EU, Britain, the UK, only increases the pension if you're living in certain countries. So that's outside the EU. Some countries, the pension is what's called updated. It's increased in line with inflation or average earnings. In other countries, it's not, but that's not a question of settled status. This has always been the case. But as far as, for example, returning to another EU state, your own state or another EU state, there's no effect at all on of Brexit on your retirement pensions. I think I wouldn't. In this case, I would actually like to get further information. Let me just see if I understand the question correctly. Now, it is right that you receive your settled status, and it is an online database, and the UK gives you an attached letter, which is usually sufficient to show you have settled status. Now, the one reason they may want to know about a new passport is because the passport is one of the security questions to get you into your application, to stop other people looking at your private information. So they do ask you to let them know if there's changes in your, if you renew your passport, it will be a new passport number. Now, that doesn't mean you lose settled status. It just means it's a security device, if you like, to make sure you can look at your own application. And this could be important. For example, if you want to work in many years' time, the employer might accept the letter you're given, but they might say, we'd like to check the database. So can you give us, can you please access the information? So it is right on the settled status decision letter. It does advise you to, if you do renew your passport, to change the details on your data in order that you can look at your decision. The official decision is the database, it's not the letter. But that doesn't mean you lose settled status. So if you'd like to contact me, the best way is through the email link just in case I'm missing something on the question, but it's certainly not right that you lose settled status because you renew your passport. It's a practical thing, and I don't know why the Home Office are asking to see your passport. So please contact me, and I will answer that fully. Thank you.
So there was a couple of bits regarding NHS. So will there be any charges after the cut-off points for NHS treatment for EU nationals? And there's also a query around pre-settled status. And going back to the private health insurance, is there any need for private health insurance, or can we still benefit from NHS services?
Yes, there's no change. So EU citizens who are here prior to the 31st of December 2020 and who apply for pre-settled status or settled status prior to June of 2021 will be, there's no restriction at all on accessing NHS treatment, and there's no reason why you need to take out private medical insurance. What I can't tell you is the rules for EU nationals who come here after December 2020, for example, as visitors. Probably the EHIC card will continue, but we don't know at the moment. And similarly for EU students, their right to access the NHS. But if you're in the UK at the moment, you have a right to NHS treatment, but you must apply for pre-settled status or settled status by June next year. So there's absolutely no need to take out private medical insurance.
So this is the pre-settled status. We will be able to apply for settled status. That will be after June 2021, or is there anything else that would need to be applied for?
Yeah. Yes, people get very worried about this. It does seem very strange, but there's no problem at all. The one thing you need to do, and I think the questioner has done this, is you've got to apply for pre-settled status before June 2020 if you have not lived in the UK for 5 years. If you've lived in the UK for 5 years, obviously you apply for settled status. So providing you have the pre-settled status by the end of June 2021, there is no difficulty. You're here lawfully. That's the reason for issuing you this temporary status, confirms you're legally in the UK, and then after 5 years residence, you can automatically, you have to apply, but it's very easy. We can advise you. You apply to transfer to settled status. You don't need to do anything else. There's no extra requirement. It's easier than the first application. So please don't worry if you have not been here for 5 years by June 2021. So long as you apply for pre-settled status before the end of June next year, after your 5 years in the UK, you can then apply to transfer this to full settled status or residence.
There have been a couple of questions coming through to the back end in regards to indefinite leave to remain versus settled status.
Yes.
And the rights that either convey. Could you just give us another overview of what the differences are?
Yes, we've given a lot of talks live, and we hope to do those again because it's much better to actually see your audience, and we can, it's much more polite to speak to the person asking the question. This does cause confusion. I'll try to make this simple. So if you don't have indefinite leave to remain, please switch off. It doesn't affect you. Many people don't know if they have this. So you will have to have applied. You must have applied. You don't get this automatically. So if you didn't fill in forms asking for this, you haven't got it. It stopped in 2006. So again, if you were not in the UK by 2006, you haven't got indefinite leave to remain, or if you applied for something after that date, that will not be indefinite leave to remain. It's quite straightforward if you have a card. like a residence card. It will say indefinite leave to remain. The problem is back in the 1970s, 1980s, some of the 1990s, the government used stamps in passports. Those passports will now be quite old, and it's sometimes difficult to decide if somebody has indefinite leave to remain. Again, we can advise you. Now back to the question. So both indefinite leave to remain and settled status are both resident rights. So you're not a citizen, but you can stay in the UK. You're resident here. Okay, that's the same. And again, they give you the same entitlements to benefits and housing and other things, access to the NHS, other things. The two differences is indefinite leave to remain. You do not have to apply for settled status, but we suggest you do, and that's for two reasons. One is, as I said, many people have indefinite leave to remain from a long time ago. This will be an old stamp in a passport. It's very inconvenient having to keep an old passport, having to carry this with you. You want something more permanent. But the other reason is settled status is better, because settled status is only lost after 5 years out of the UK. Indefinite leave to remain is lost after 2 years out of the UK. So it gives you longer to maybe return to your home country, people caring for elderly relations. You may want to travel around the world. So you have a longer time to come back to the UK if you needed to leave. Just by the way, indefinite leave to remain is the usual way the non-EU citizens get residence rights in the UK. So settled status is actually better than the residence rights given to non-EU citizens. But I hope I've answered the question. But again, we're receiving a lot of questions, so we have to decide on those who will cover most people. If I haven't answered the question fully, again, obviously, please contact me and I will answer you directly.
So this one is a query. I know we just touched on it slightly about the non-EU residents, but it's just some clarification over if somebody has been married for over 2 years, what are the chances of gaining settled status? Is it a case by case, or is there a general rule? So as an example, if someone was married to an EU citizen for 2 years, or if they were married to a British person for 2 years.
Right, I'm going to deal with the second one first, because sometimes this causes confusion. So I think we're talking about a non-EU citizen married to a British citizen. I think we're told more than 2 years. Now, usually this has nothing to do with settled status, has nothing to do with Brexit. The reason is that EU law and settled status have to do with EU citizens from other EU states when UK was in the EU, and their rights to move here. So it would not affect UK citizens and UK family members because they're already here, they're not moving. Now, where it becomes slightly complicated is sometimes family members who are not EU citizens who are married to UK citizens can rely on the settled status scheme. I'll just say this briefly because it is complicated, and that's where the British citizen went to work in another EU state and then returned with their non-EU spouse. Okay. So they went abroad to another EU state and returned with their non-EU spouse. Now, in that case, it is slightly more complicated. But in that case, it can be possible for the non-EU spouse to rely on the settled status scheme. You might say, well, surely the spouse can remain. Well, they almost certainly can. But the reason is there are differences between how British citizens and their spouses are treated and EU citizens and their spouses. So usually the rules are much harder for the spouses of British citizens. It may sound strange, but this is true, than the spouses of EU citizens. But in certain cases, the non-EU citizen can be treated as the the non-EU citizen who is a spouse of a UK national can use the settled status scheme. That is complicated, and I certainly would ask you to contact us for advice. Now, the other point, again, I'm afraid I do need a bit more information. We're talking about the non-EU spouse, I assume, of an EU citizen. If the couple are living in the UK, even if they're living apart, that's not a problem. The EU citizen can apply, obviously, for settled status. The non-EU spouse can apply because they're a family member of an EU citizen. And again, provided they have the 5 years, the non-EU citizen can apply for settled status. Where it becomes complicated is if the non-EU spouse is divorced or the EU partner dies, or the EU partner permanently leaves the UK, because in those cases the marriage has ended and the non-EU person is not then the spouse of an EU citizen. So again, in that case, because it's both of these examples, I'm afraid, are quite complicated, please get advice. I would say any non-EU family member who's not living with an EU citizen really should get advice. There is usually not a problem, but sometimes we need more information before you make the application. So again, please contact us on that. I need more information to answer your question.
So that will bring us to the end of our Q&A session. So I would firstly just like to remind everybody regarding our our feedback form, sorry. So that should be displayed now. And we'll also post another quick note into the Q&A section. So if you click on that question mark at the top right hand corner of your screen, you should be able to see the link. Thank you to those who have already completed it, but it would be very helpful if you can give us that feedback so we can make sure that any future webinars are as tailored to what suits our residents as possible. Thank you very much. And I believe our CEO is going to do some closing remarks, so I will pass over to him in just a second. Just the very last prompt for if you do want some more information from us regarding EU or any other information, the contact details for us should be up on our screen. But if you go to our website, which is www.citizensadvicerichmond.org, you can fill out a form which you'll be able to get some specific advice, and we can make sure that it goes to an appropriate advisor that way, such as Mike if it's an EU query, or you can call our helpline, which is open Monday to Friday, 10 AM to 4 PM, and that's on 0300 330 2114. Our advisors will take some information. They may be able to answer your query there and then, but we may need to call you back to give you some further advice. I will now pass you over to Simon. So thank you all very much and speak to you soon.
Okay, thank you very much, Bradley. Thank you to everybody who has attended this afternoon. I hope that you found the webinar useful. If you didn't have your questions answered, or if you still need any further advice, remember that although the webinar is coming to a close now, we are still here for you. We have a special project to help EU citizens in the borough, which is funded by Richmond Council, and Mike is the specialist caseworker on that project. At the moment, we can offer advice only by phone and by email, but details of how to contact us are on the website at citizensadvicerichmond.org, and I think we've flashed up the contact details and the telephone number throughout the webinar. As Bradley says, this is our very first webinar, so we'd be really grateful if you could fill out the feedback form and let us know what worked and what didn't work. If I can persuade Mike and my colleagues to do another one, then we hope to do this webinar again in future. So it'd be really useful for us to let us know what the feedback is and what you thought about it. Finally, I'd just like to thank everybody who has been involved in producing this webinar. Thank you to Mike, who has presented it and brought his expert knowledge to bear, both in developing the presentation and also answering your questions. Thank you to Bradley, who moderated the questions as well and picked out the best ones. I hope he didn't just pick out the easy ones. I hope he picked out some of the more difficult ones. Thank you to Sarah, who helped us with some of the administration and setting up the webinar. And thanks particularly to David, our IT volunteer, who has worked tirelessly over the past few weeks to get everything ready, set everything up and make sure that the tech worked for us, and also I think help some people who weren't able to join straight away. So thank you to all the staff and volunteers at Citizens Advice Richmond for helping to bring this webinar about. That's the end of our webinar. Keep an eye on our website. Details of any future events will appear there, and if you'd like to go onto our mailing list, then again the details of how to sign up for that are on our website. Thank you very much, everybody. That's the end of our webinar now.